Hi, I'm David de Freitas, father of Eleanor de Freitas. On the 4th of April 2014, my daughter Eleanor took her own life. Eleanor, who had bipolar, was about to face a public trial for allegedly lying about a rape allegation she made against a wealthy man, Economou. This prosecution was started as a private prosecution by this same man using his family's vast wealth. In our opinion, this prosecution was vengeful and intimidating. At the time, we asked the Crown Prosecution Service, the CPS, to stop it. Instead, they took it over and continued it, without following the legal protocol to hear both sides of the story. The police, who had heard both sides of the story, most emphatically did not support this prosecution. They made this very clear to the Crown Prosecution Service, and the CPS has never detailed how the police were wrong in their view and why they didn't follow their recommendations. Because the CPS continued his private prosecution, this wealthy man, Economou, was able, perfectly legally, to recoup his costs of £203,050.11 from the Legal Aid Fund. He was also vengeful towards me. At a time when I was a newly grieving father seeking justice for his daughter, Economou sued me for libel. In dismissing his libel claim against me on grounds of public interest, I was the first person to use the public interest defense successfully. This libel judge described Economou as being offensive and bullying with elements of vengefulness. Before I explain how and why I need your help, let me say this. I know that fathers can look on their daughters through rose-tinted lenses, and I freely admit that I really loved my daughter Eleanor. I cannot tell you how deeply devastated I was by the death of my daughter Eleanor. To say that she meant the world to me doesn't even touch it. I know I will have your compassion and sympathy, but I also want to appeal to your sense of fairness and justice. I am calling for a full public inquiry into the CPS's handling of this private prosecution for two main reasons. Firstly, Dame Alison Saunders, head of the CPS at the time, wrote a letter to me dated the 3rd of December 2014 in which she attempted to justify the CPS's decision to continue this private prosecution. In my opinion, this letter demonstrates an inaccurate understanding about consent. Let me quote directly from her letter. Eleanor's complaint involved various things being done to her as part of a sexual attack. These things were, however, foreshadowed in the text exchanges on the 22nd of December, in which they were discussed and agreed by her. These texts did indeed set out the boundaries for their one and only date the following day. There are 3 texts in which Ellie wrote, "No kissing, no touching erogenous zones, stick to the rules, no sex, no kissing, etc." How do the words "no sex" foreshadow agreement to a sexual attack? I wrote to Suella Braverman, Attorney General at the time, with oversight responsibility for the Crown Prosecution Service, and I asked her if she understood how the words "no sex" foreshadowed agreement to a sexual attack. I also asked her if she accepted that a woman has the right to change her mind at any time. So even if Eleanor had agreed to sex the day before, that would not commit her 24 hours later or even 24 minutes later. She declined to answer those questions and all the others that I put to her. In earlier texts, Alexander Economou made several jokes about what he liked to do to women, including "slip a little surprise in those cocktails, ha ha." I like the opposite, someone I can tie up and torment. All of this came out in the libel trial, where Alexander Economou maintained that his sex with Eleanor was consensual. Economou even laughed during his police interview after he had been arrested. Both Suella Braverman and the CPS were aware of all of this. My second reason: the evidence which should have been the Crown Prosecution Service's strongest evidence against Eleanor for supposedly lying, namely Eleanor's videotaped interview with the police, was placed in unused evidence, which means they considered it evidence not relevant to their prosecution. How can that make any sense? The court ordered the Crown Prosecution Service to disclose this videotape to Ellie's defence team by the end of February 2014. In 2013, the CPS had written to the trial judge confirming they had received this videotape from the police and viewed it. So all the CPS had to do was hand it over. But the Crown Prosecution Service did not obey this court order until less than a week before Eleanor's trial, so 5 weeks after the deadline. A delay which Dame Alison tried to convince me was the fault of the police. It wasn't. When Ellie's defence team finally viewed the tape, they realised that Eleanor had not in fact made a clear accusation of rape. This is not unusual where severe trauma is perceived, but a clear accusation of rape is essential for this kind of prosecution. On realising there was no clear accusation, Eleanor's defence team decided that Eleanor would now not have to take the witness stand and face the ordeal of cross-examination, which is something that any woman would find deeply traumatic, particularly a young woman diagnosed with bipolar. Instead, they would simply play her videotape as her evidence. They decided to give Eleanor this good news at their next meeting with her before her trial started. Tragically, Eleanor took her own life earlier that day on the 4th of April 2014. A few months after her death, we discovered the Crown Prosecution Service had completely ignored the clear warning of suicide contained in a psychiatric report they had received 4 months before Eleanor died. I firmly believe that if the Crown Prosecution Service had taken heed of that psychiatric report and obeyed the court's order and delivered Eleanor's videotape on time, that my daughter Eleanor would still be alive today. There is so much more that you need to know that is murky about this prosecution. However, I was made to sign a gagging order by the Crown Prosecution Service before they would allow me access to a report which would decide how we could take this case forward. This gagging order was fully supported by Jeremy Wright as Attorney General and every Conservative Attorney General since, including Suella Braverman. This report details even further failings by the Crown Prosecution Service, but I am legally gagged from telling you. Over the past 10 years, I have discussed Eleanor's case with over 60 lawyers, including Harriet Wistrich of the Centre for Women's Justice. They have all been in unanimous agreement. The Crown Prosecution Service should have stopped this private prosecution dead in its tracks. Indeed, in Harriet's own words from her book Sister-in-Law, where she devotes a whole chapter to this case, she says, "I was both mystified and horrified by the apparent complicity of the CPS in the actions that resulted in this young woman taking her own life. The charity Victim Support, who do not normally get involved in individual cases, had this to say: Victim Support is concerned in principle about the use of private prosecutions against rape complainants. In particular, we are concerned that the use of a private prosecution in such circumstances enables the subject of the rape complaint to lawfully take actions which would necessarily intimidate the complainant. Unless there is a full public inquiry, we will never know why the CPS didn't follow their own protocol and interview Eleanor under caution so they could hear her side of the story, why the CPS failed to follow the court's order and delivered pivotal video evidence 5 weeks late, why the CPS completely ignored the clear warning of suicide, why the CPS were so willing to ignore the clear advice of the police who had first-hand experience of both individuals, why the CPS were so willing to support a man who jokes about drugging women and tying them up and laughed during his police interview, why the CPS were so willing to support a man whom a High Court judge described as offensive, bullying, and vengeful. And finally, how the CPS could even think that the words "no sex" foreshadowed agreement to a sexual attack. After 10 years, our questions remain unanswered. In my quest for justice for Eleanor, I have got nowhere with the last 5 Conservative Attorneys General. Lord Hermer is the first Labour Attorney General in 14 years. In his acceptance speech on being appointed Attorney General, Lord Hermer committed himself to talking truth to power. So I'm calling on Lord Hermer to do 2 things. 1, order a full public inquiry into the conduct and decision-making of the Crown Prosecution Service in continuing this private prosecution against my daughter Eleanor. 2, remove the gagging order on Harriet and me so that we can fully, publicly expose the failings of the CPS in this case. I'm asking you to please help me by lobbying Lord Hermer for a full public inquiry to get justice for Ellie and other vulnerable women. You can do this in 2 ways, and I hope you do both. The first way, please click on the link in the email that gives you access to my petition on change.org and enter your details there. For the second way, please use the draft letter that I have prepared and email it to Lord Hermer. All that you need to do to this draft letter is to add today's date on the first page and your name on the last page. This draft letter is either attached to the email that gave you access to this video clip, or you will have a link to it. I do hope that this is the last year we have to face with no answers. Thank you.